Ladies and gentlemen of the jury, you will be presented with a case that involves armed robbery and assault. Please keep in mind that the defendant should be presumed innocent until proven guilty. The burden to prove the defendant guilty beyond a reasonable doubt rests solely on the prosecution. The defense does not have anything to prove. Prosecutor, you may begin with your opening statement.
On the evening of April 17, 2010, Mrs. Wilson, the victim, was assaulted and robbed outside of her residence as she returned home from work. During this encounter, Mrs. Wilson was knocked unconscious and her purse was stolen. Today, using the testimony of an eyewitness and arresting officer, I will prove to you that the defendant has committed this despicable act. Thank you.
Defense, you may present your opening statement.
My client has been caught in an unfortunate and tragic set of circumstances. He was misidentified by the eyewitness and has been falsely accused of a crime that he did not commit. I will show you the weaknesses in the prosecution's case. After considering everything I have to say today, you should find my client not guilty of the crimes of which he has been accused. Thank you.
Please call your witness, prosecutor.
I would like to call Mr. Steve Johnson to the stand.
Please state and spell your name for the court and give your address.
My name is Steve E. Johnson, Johnsson, 1337 Emerald Avenue, Providence, Rhode Island.
Please be seated.
Mr. Johnson, could you please explain, in your own words, what happened on the evening of April 17, 2010?
My wife and I just finished eating dinner at our house. I was in the kitchen washing dishes while my wife is doing other housework.
Around what time was this?
It was about 6:10 or 6:15 p.m.
Please continue.
At our kitchen sink, there is a window that looks out into Miss Wilson's property.
Are you and Mrs. Wilson good neighbors?
We don't know each other really well, but we say hi or engage in small talk when we see each other outside on occasion.
Okay. What happened next as you were washing dishes?
As I glanced up, something caught my attention outside. I saw a man grabbing Miss Wilson and pointing a gun to her head. The man proceeded to shove Miss Wilson and then hit her over the head with a black revolver. Miss Wilson fell to the ground, and it looked like the man ran off with her purse.
So, Mr. Johnson, what did you do?
I asked my wife to call 911 while I went to the next door to check on Miss Wilson. I checked to see if Miss Wilson had a pulse, which she did. I watched over her until help arrived. The paramedics and the police arrived to the scene within minutes. She started to regain consciousness shortly after.
What else happened that night?
I was interviewed by Officer Davis. I told him what happened.
What did you tell him?
Everything I just described to you.
Did you tell him anything else?
Yes, I also described the man to him.
What did the man who assaulted and robbed Mrs. Wilson look like?
He was Caucasian, male, and about 5'10", 200 pounds, with dark hair and a beard. His facial skin tone was reddish, like when someone blushes. He was wearing black pants and a black polo shirt.
How long did you look at him?
The part of the confrontation that I witnessed took about 10 seconds.
Do you think that was enough time to get a good look at him?
Yes, I do. I really tried hard to study the man so that I could describe him to the police.
How close were you to this confrontation as it happened?
Our houses are close together. There's just a strip of lawn between us. I would say that I was no more than 15 feet away.
So close enough to get a good view.
Yes, I really tried hard to study the man.
Did anything else happen that evening?
Yes, I worked with a sketch artist to develop a composite sketch of the man.
Mr. Johnson, have you seen the man who assaulted and robbed Mrs. Wilson since the evening of April 17th?
Yes.
When was that?
The police asked me to look at some pictures and try to pick out the person who assaulted and robbed Miss Wilson.
And what happened?
I picked out the picture of the man I saw.
Is that person in the courtroom today?
Yes, he is.
Could you point him out, please?
He's sitting right over there.
For the record, Mr. Johnson pointed at the defendant, Roger Green. Mr. Johnson, how confident are you that Roger Green is the man who robbed Mrs. Wilson?
I am 100% positive.
Thank you, Mr. Johnson. I have no further questions, Your Honor.
Defense, your witness.
You said that you viewed the confrontation for only about 10 seconds, right?
Yes, that's right.
So overall, you didn't look at the man for very long, did you?
I had enough time to study the man.
But only 10 seconds, right?
Correct.
And yet you say that you are 100% positive that you identified the right person?
Yes, that's right. I'm 100% positive.
Mr. Johnson, am I correct when I say that you identified my client from a police lineup sometime after the crime?
Yes.
And how long after the crime occurred did you make that identification?
It was 2 days later.
Did you indicate how confident you were at the time you initially made your identification as per best practice recommendations?
Yes.
Your Honor, I would like to enter into evidence the statement that Mr. Johnson made on the day of his identification.
Accepted.
Mr. Johnson, is this the statement you completed on the date of the identification?
Yes, it is.
Would you read what you wrote on the day of your identification for the court, please?
I wrote, I picked out photograph number 3. I'm 75% positive.
I'm sorry, I couldn't hear you with the noise outside. Could you repeat what you just said?
I wrote, I picked out photograph number 3. I'm 75% positive.
So when you made your identification, you were 75% positive. And yet, a few moments ago, you reported that you are 100% positive that my client is the man who assaulted and robbed Mrs. Wilson. Memory doesn't get better with time, Mr. Johnson. How did that happen? Why are you more confident now than you were then that my client is the man who assaulted and robbed Mrs. Wilson?
I've been rehearsing my testimony a lot, but the lawyers and the police are prepared for court. I've become more confident each time I've rehearsed my testimony.
Mr. Johnson, are you saying that you have become more confident now because you have been rehearsing your testimony?
Yes, each time I rehearsed my testimony for the court with the lawyers and the police, I became more confident.
I have no further questions, Your Honor.
Prosecutor, any redirect?
Mr. Johnson, how confident are you right now that you made an accurate identification?
I am 100% positive.
Thank you. I have no further questions.
Prosecutor, please make your closing remarks.
Ladies and gentlemen, after hearing the testimony, I think you will agree with me that all of the evidence adds up. There's an eyewitness that places Mr. Green at the scene of the crime. Based on this evidence, I believe it is your duty to find Mr. Green guilty.
Defense, your closing statements?
Ladies and gentlemen, I disagree with my colleague's assessment. The prosecution has not shown anything that proves with absolute certainty that my client committed this crime. Even the lone eyewitness is not 100% sure. For this reason, I feel that you are obligated to find my client not guilty.
Ladies and gentlemen of the jury, you will now be asked to listen to a set of instructions. Consider these instructions carefully when deliberating the evidence you have heard in today's trial. The defendant, as part of his denial of guilt, contends that the state has not presented sufficient reliable evidence to establish beyond a reasonable doubt that he is the person who committed the alleged offenses. The burden of proving the identity of the person who committed the crime is upon the state. For you to find this defendant guilty, the state must prove beyond a reasonable doubt that this defendant is the person who committed the crime. The defendant has neither the burden nor the duty to show that the crime, if committed, was committed by someone else or to prove the identity of that person. You must determine, therefore, not only whether the state has proven each and every element of the offenses charged beyond a reasonable doubt, but also whether the state has proven beyond a reasonable doubt that this defendant is the person who committed it. The state has presented the testimony of Mr. Johnson. You will recall that this witness identified the defendant in court as the person who committed the crime of armed robbery. The state also presented testimony on a prior occasion before this trial. This witness identified the defendant as the person who committed these offenses worthy of belief. You must decide whether it is sufficiently reliable evidence that this defendant is the person who committed these offenses charged. Eyewitness identification evidence must be scrutinized carefully. Human beings have the ability to recognize other people from past experiences and to identify them at a later time, but research has shown that there are risks of making mistaken identifications. That research has focused on the nature of memory and the factors that affect the reliability of eyewitness identifications. Human memory is not foolproof. Research has revealed that human memory is not like a video recording that a witness need only replay to remember what happened. Memory is far more complex. The process of remembering consists of 3 stages: acquisition, the perception of the original event; retention, the period of time that passes between the event and the eventual recollection of a piece of information; and retrieval, the stage during which a person recalls stored information. At each of these stages, memories can be affected by a variety of factors. Relying on some of the research that has been done, I will instruct you on specific factors you should consider in this case, in determining whether the eyewitness identification evidence is reliable. In evaluating this identification, you should consider the observations and perceptions on which the identification was based. the witness's ability to make those observations and perceive events, and the circumstances under which the identification was made. Although nothing may appear more convincing than a witness's categorical identification of a perpetrator, you must critically analyze such testimony. Such identifications, even if made in good faith, may be mistaken. Therefore, when analyzing such testimony, be advised that a witness's level of confidence standing alone may not be an indication of the reliability of the identification. If you determine that the out-of-court identification is not reliable, you may still consider the witness's in-court identification of the defendant. If you find that it resulted from the witness's observations or perceptions of the perpetrator during the commission of these offenses and that the identification is reliable, if you find that the in-court identification is the product of an impression gained at the out-of-court identification procedure, it should be afforded no weight. The ultimate question of the reliability of both the in-court and out-of-court identifications is for you to decide. To decide whether the identification testimony is sufficiently reliable evidence to conclude that this defendant is the person who committed these offenses charged, you should evaluate the testimony of the witness in light of the factors for considering credibility that I have already explained to you. In addition, you should consider the following factors that are related to the witness, the alleged perpetrator, and the criminal incident itself. In particular, you should consider the witness's opportunity to view and the degree of attention. In evaluating the reliability of the identification, you should assess the witness's opportunity to view the person who committed these offenses at the time of these offenses and the witness's degree of attention to the perpetrator at the time of these offenses. In making this assessment, you should consider the following. Stress. Even under the best viewing conditions, high levels of stress can reduce an eyewitness's ability to recall and make an accurate identification. Therefore, you should consider a witness's level of stress and whether that stress, if any, distracted the witness or made it harder for him or her to identify the perpetrator. Duration. The amount of time an eyewitness has to observe an event may affect the reliability of an identification. Although there is no minimum time required to make an accurate identification, a brief or fleeting contact is less likely to produce an accurate identification than a more prolonged exposure to the perpetrator. In addition, time estimates given by the witness may not always be accurate because witnesses tend to think events lasted longer than they actually did. You should also consider distance. A person is easier to identify when close by. The greater distance between an eyewitness and a perpetrator, the higher the risk of a mistaken identification. In addition, a witness's estimate of how far he or she was from the perpetrator may not always be accurate because people tend to have difficulty estimating distances. Consider the lighting. Inadequate lighting can reduce the reliability of an identification. You should consider the lighting conditions present at the time of the alleged crime in this case. Disguises or changed appearance. The perpetrator's use of a disguise can affect a witness's ability to both remember and identify the perpetrator. Disguises like hats, sunglasses, or masks can reduce the accuracy of an identification. Similarly, if facial features are altered between the time of the event and a later identification procedure, the accuracy of the identification may decrease. Consider prior description of the perpetrator. Another factor for you to consider is the accuracy of any description the witness gave after observing the incident and before identifying the perpetrator. Facts that may be relevant to this factor include whether the prior description matched the photo or person picked out later, whether the prior description provided details or was just a general in nature, and whether the witness's testimony at trial was consistent with or different from his or her prior description of the perpetrator. Confidence and accuracy. As I explained earlier, a witness's level of confidence standing alone may not be an indication of the reliability of the identification. Although some research has found that highly confident witnesses are more likely to make accurate identifications, eyewitnesses' confidence is generally an unreliable indicator of accuracy. Finally, consider the amount of time that has elapsed. Memories fade with time. As a result, delays between the commission of a crime and the time an identification is made can affect the reliability of the identification. In other words, the more time that has passed, the greater the possibility that a witness's memory of a perpetrator will weaken. Keep in mind that the presence of any single factor or combination of factors is not an indication that a particular witness is incorrect. Instead, you may consider the factors that I have discussed as you assess all of the circumstances of the case, including all of the testimony and documentary evidence. In determining whether a particular identification made by a witness is accurate and thus worthy of your consideration, as you decide whether the state has met its burden to prove identification beyond a reasonable doubt. If you determine that the in-court or out-of-court identifications resulted from the witness's observations or perceptions of the perpetrator during the commission of these offenses, you may consider that evidence and decide how much weight to give it. If you instead decide that the identification is the product of an impression gained at the in-court and/or out-of-court identification procedures, the identifications should be afforded no weight. The ultimate issue of the trustworthiness of an identification is for you to decide. If after consideration of all of the evidence, you determine that the state has not proven beyond a reasonable doubt that Mr. Peter Brown was the person who committed these offenses, then you must find him not guilty. If, on the other hand, after the consideration of all of the evidence, you are convinced beyond a reasonable doubt that Mr. Peter Brown was correctly identified, you will then consider whether the state has proven each and every element of these offenses charged beyond a reasonable doubt.